With that, I took a lot of time, so let me turn it over to Mike Trackman. Most of you know him already. He's our partner from the outside and does a great job in kind of helping us see what's coming down the pipe. Mike.
Thanks, Kevin. Nice to be here. Hopefully, I share your wish that we can do this in person again and get past the current difficulties. But for now, I'm happy to have the opportunity. So thank you again. I want to talk about independent contractors today, mainly because with change of the administration, there are some changes that are coming down the pike, and they're very significant from the point of view of both economics, business organization, how you run your company, et cetera. And I think that forewarned is forearmed, and that's basically my purpose in speaking with you today. So why is this important? What it's all about? Classifying someone as an independent contractor makes a huge financial and practical difference to a business, as I'm sure many of you know. When you have someone working as an independent contractor, you don't know that person overtime. You don't know that person benefits. The employment laws, ADA, FDA, harassment, discrimination, don't apply to an independent contractor in the same way. There's no FICA that you're paying. There's no payroll withholding. So there are huge advantages to a company who can employ independent contractors instead of normal W-2 employees. The problem is that there is some risk, significant amount of risk, much to my dismay, about to get a lot worse, as I'll talk about in a few minutes. But there's significant risk if you misclassify someone who should be an employee as an independent contractor. Again, as many of you know, there have been audits on both the federal and state level of many companies, back overtime, back attorneys' fees, ACA, health insurance issues, et cetera. So understanding the line between who's an independent contractor lawfully and who you can classify as an employee is a significant issue for business management. This has been very confusing over the course of the years. The IRS has one standard for tax purposes. The departments of labor at the federal level has one standard, and at state levels have other standards. The labor lobby has been very active in lobbying for a tightening up of what an independent contractor is as opposed to an employee. As I'll discuss, the business lobby, so too, but in the opposite direction. The government has had its eye on this because estimates are hundreds of millions of dollars are lost when companies classify workers who should be employees as independent contractors. FICA is lost, payroll withholding is lost, et cetera. And then comes the gig economy. What exactly a gig worker is and how to define it is something that's difficult to get your arms around. But basically, we're talking about more hit and miss engagements by individuals who are doing certain work, people who work when they want as opposed to according with a set schedule, and serve as drivers or clerical employees, or sometimes programmers, accounting personnel, designers, marketing people, researchers. And the question as to what to do with gig workers in terms of overtime, benefits, and the like has plagued a variety of states and a variety of courts. There's been all kinds of litigation involving Uber and Lyft, for example, in a couple of different states, mainly California. So it's a very confusing area with huge economic and practical management consequences. The Trump administration addressed this, or attempted to address it, towards the end of the Trump administration, and put forth some regulations which were not yet adopted, which were in limbo, which came to be known as the economic realities test in terms of defining who could be classified as an independent contractor in your organization. This is very much tilted in favor of businesses as opposed to in favor of workers. And the economic realities test, which conforms with a lot of existing law, basically said that and I'm simplifying here, but basically said that if a worker controlled the key aspects of work, what the worker did, how the work was done, et cetera, which is true with an awful lot of exempt employees. And if the worker had basically some skin in the game, the worker could make a profit depending upon how well he or she or how efficiently performed, which means that a company could pay a flat fee. And if the worker got the job done more quickly or could provide bonus or incentives, then you could properly classify that worker as an independent contractor. It made it substantially easier than it would otherwise be to classify someone an independent contractor. It was just basically an arrangement of get it done, and you can make more money if you get it done quickly and well. And then that person would largely qualify as an independent contractor. One of the key campaign planks in the Biden administration, however, was to completely do away with that and reformulate that. And the Biden administration has been working on that very diligently, which has caused me to suggest to MEA that this particular presentation be granted because stuff is coming down the tracks now as we speak. Over the last few days, the final stages of efforts by the Biden administration to undo what the Trump administration had started here is working its way through. That's almost finalized, may lead to litigation. The Biden administration engaged gentleman Martin Walsh, the former mayor of Boston, to be the Secretary of the Department of Labor. Marty Walsh, as he is known, is very much opposed to the way that independent contractors have been defined in the past, very much in favor of extreme tightening procedures to make it much more difficult for companies to classify workers as independent contractors. He gave a speech on April 29, just a few days ago, which was picked up in the national media, of saying we're about ready to move here. National media also reported the other day that a former official who has been very vociferous in terms of talking about the gig economy and how gig workers are treated is about to be approved by the Senate as the head of the Fair Labor Standards Act administration. So there's stuff that's going to be going on. There are legal questions in terms of how far the administration will be able to go in tightening up independent contractor definitions without amending the Fair Labor Standards Act, et cetera. And on top of this, in addition to what the federal government is doing, the states are getting actively involved. And as many of you know, the states can get much more severe than the federal government here. As I'll discuss in a second, California has led the way and has made it very difficult to classify workers as independent contractors. Massachusetts has followed suit. In Pennsylvania and Delaware, things are still pretty much along the lines of the economic realities test. New Jersey, on the other hand, has become much more strident in wage payment, overtime issues in terms of who can and cannot be an independent contractor. So lots are in flux, lots is in flux at the state level as well. So the upshot of all of this is that there's going to be changes. Exactly the landscape and the timing of those changes, we don't know. Courts will probably be involved, state legislatures will be involved, but the time has come to really seriously start thinking about that. And I wanted to start that process with you this morning. So where are we going with this? The most influential test, if we can call it that, of an independent contractor that's toward this whole area of making things much tighter was pioneered in California, and it's known as the ABC test. The media refer frequently to the ABC test in terms of redefining how you will be required to classify workers. But this is the way it is in California now. New Jersey has adopted some of this in certain contexts. Massachusetts has, other states have as well. Basically, the ABC test, as compared to what we typically have done in the past, is the following. The A part is that in order to be classified as an independent contractor, the worker has to be truly free from control or direction by the company that hired the worker. So if you are telling the worker when to report, basically what to do, even if the worker has substantial freedom and discretion in how to get it done, that probably won't qualify for independent contractor status. Lots of gray areas there, but the worker has to be very substantially free to decide how and when he or she does the work. The B of the ABC test, I think, is the focal point. And I think it's going to be the focal point going forward. The B of the ABC test is that in order to be an independent contractor, the worker has to be assigned to perform tasks outside of the usual course of the company's business. So, for example, if you hire as an independent contractor someone to do clerical work or accounting work or programming work, which is part of your business, even though that person is a 1099, even though that person comes and goes as he or she pleases, and even though that person decides substantially how and when to do the work, if it's the kind of work that is typically within the ambit of what your business does, that person will not be classifiable as an independent contractor under the ABC test. And that's the biggie. That's where the focus is going to be. The C of the ABC test is that the worker cannot be an independent contractor unless the worker is engaged basically as his or her business in some trade or profession that you've hired that person for, a plumber, electrician, something along those lines. But it's basically, a temp worker who is there to be available to do anything or anything. That's not an independent contractor. So the ABC test, bottom line, is that it's very, very difficult under that test to classify someone as an independent contractor as compared to the way things have been historically. And one other aspect to this as well, which is worth my pointing out, because among my clients, I occasionally run into a company that has misconstrued this. If you hire someone from a staffing agency, for example, there are companies who believe that they can classify those people who come to work in your company as independent contractors because they're supplied by an outside staffing agency. Not so. We don't have time to go into the details of that today, but there's a doctrine in law called the joint employment doctrine, and those people are going to be both employees of the staffing agency and your employees, particularly if they're doing the kind of work that typically gets done in your company, and it just happens that they're supplied by a staffing agency. So be careful with respect to that. So having said all that, what now? Where do we go? And as I said, my purpose is to alert you to the possibilities and to provide you with some early guidance in respect to where we're going and what you ought to be doing and how you ought to be addressing these changes that are going to be coming at us fairly soon. I'll make some predictions off the top with respect to where I think things are going to be over the next several months. Number one, I think the federal government is going to try to get as close to the ABC test as the federal government can. And this is no big secret. This was in the Biden campaign literature. This is something that President Biden has talked about for a long, long time. President Biden is a supporter of the ABC test. Whether or not it can be implemented fully is a real legal question right now, because many people feel you have to amend certain laws, which are probably not going to pass the Senate at that time, but the federal government's going to try. And even if they cannot get it instilled fully into the law, they will change enforcement priorities at the Department of Labor level in terms of choosing how and where they send the audit teams and the enforcement teams. So there's going to be a big push toward the ABC test at the federal level. Secondly, among all the prongs of the ABC test, those three prongs, I think B is going to be the focus here. And I think if you're hiring people and classifying them as independent contractors, and they are performing work which is basically within the parameters of the work that you do. If you're a software company, they're programmers. If you are any business that has accounting or clerical functions and you're hiring people to perform those tasks that are ordinarily performed by or could ordinarily be performed by employees, I think in the future, we're all going to have a very hard time of classifying those people as independent contractors if they perform those kinds of tasks for your business. Number three prediction, and again, I'm not pulling this out of thin air. This is already in the works. It's been talked about by Marty Walsh, by President Biden. The penalties for violating the independent contractor classification strictures are going to get ramped up dramatically. There have been people in the administration who've even talked so far as to making some of this a criminal violation. The feeling is among the current administration personnel that many companies are violating these classification strictures because the advantages are, as I've described, very significant. Enforcement has been hit and miss, and if you get caught, it's not really all that bad in many respects. The stated goal of the Biden administration is to change that and to make the penalties for misclassification of employees as independent contractors absolutely intolerable, raising the stakes dramatically so that companies will be very much less inclined to take the chance. A fourth prediction I'll make is that the states are going to become much more active in respect to this, no matter what the federal government does. The states have freedom to do what they want. They're not bound by federal law like the Fair Labor Standards Act that we've all dealt with and the like. They can make their own laws with respect to that if they protect workers even more than the FLSA does. And many states have legislation pending for that purpose. It's a big social issue right now of providing benefits and overtime to workers who have been excluded from those privileges over time through gig worker concepts and independent contractor concepts. And in terms of gig workers, people who, again, just show up for a day or two or hit and miss, there's a big push on to reclassify them into a third category, not independent contractors and non-employees, but into a third category where there may be some benefits that are attributable to them and the like. So these things are all on the table right now. These are what's being talked about. And if you're a company that typically has hired independent contractors or has utilized independent contractors or has been a little bit flexible, willy-nilly, not worrying that much about who's an independent contractor and who's classified as an employee, the time has come to start putting a magnifying glass on this. So what do you do in terms of some specific advice that I want to provide to you? Number one is you've got to stay up to date. We don't know exactly where this is heading. We just know it's heading in a direction opposite of where we've been. We've got your back with respect to that. MEA will stay on top of that. I'll continue to work with MEA to provide the updates that are necessary to the extent that I can and I needed to do so. But keep an eye on this. There was a very strategic announcement that on April 29, as I mentioned, to kind of, in my judgment, grease the skids for some real actions that are going to be coming now. If you use a lot of independent contractors or gig workers, assess the risk now, right now. This will be a budgeting issue. This will be an issue of who's now going to be governed by employment laws, such as the ADA, the FMLA, harassment laws, discrimination laws. So that takes training, and that takes all the kinds of things in terms of the ambit of services that MEA provides in terms of managing employees and minimizing your risks. But those who you've classified as independent contractors will very likely, significant portions of them, be within that circle that you'll have to worry about. Managing overtime, it's, one of the big things with independent contractors is you didn't have to worry about overtime, paying time and a half. If they are classified as employees or you're required, those independent contractors will now be subject to time and a half overtime, which is a management burden that you may have thought you didn't have to worry about before because they were independent contractors, but you will have to worry about it going forward at some point and at some level. So you just keep that on your radar screen. There's very good argument in my judgment, depending upon the nature of your business and the nature of your company, to take a preemptive strike here. That if you are significant in terms of your utilization of independent contractors, key people in key positions, it may be very much worth your while to convert those people to employees now when there's not a gun to your head while you still have the bargaining leverage. So for example, there are many companies I know, many clients I represent, who will hire key accounting personnel as independent contractors, even people at the CFO level to work as an independent contractor, key research people, depending upon the nature of the organization, people that they really rely upon, that they felt that they could classify as independent contractors under the prior testing, but will not be able to do that in all likelihood in the future. It's worth thinking about whether to convert those people to employees now, while it's not in the headlines, while you still have the bargaining leverage with those people. And if you're thinking along those lines, I want to end by making 2 points with regard to the advantages of converting an independent contractor, particularly a truly important person who's working as an independent contractor, to employment status. We talked about the advantages of independent contractor status, but I think it's worth talking about 2 things that you should have on your radar screen about converting independent contractors to employees. One has to do with intellectual property. One has to do with the work product that workers in your business create. And if you're using independent contractors to create computer programs, to create graphic designs, to create marketing plans, and the like. You need to understand what a lot of companies do not understand, to their detriment, that when someone is working as an independent contractor and creates that kind of intellectual capital, be it graphic or lines of code or whatever, that intellectual property belongs to the independent contractor. Even if you obviously are the person who paid the independent contractor to provide it and create it, the independent contractor owns it. So you have a license to use it for the limited purpose for which you engage the independent contractor, but the independent contractor owns it. I see this all the time among my clients, for example, in instances where someone hires a photographer to take some pictures for a website. The independent contractor photographer owns those pictures. You're allowed to put them on the website, but then companies take the photos perhaps and use them for other promotional purposes, put them in a brochure, violation of the copyright laws. You only had a license to use that for the purpose for which you engaged the independent contractor. So this is an important advantage, because the opposite is true in regards to employees. If someone creates intellectual property while in the capacity of an employee as opposed to an independent contractor, the employer owns that intellectual property. So as you are converting independent contractors to employees, you could take advantage of an employment agreement which will assign all prior independent contractor generated intellectual property to you in that employment agreement, take away a lot of those issues that you may have otherwise faced on down the line because of the independent contractor relationship, convert it to an employment relationship, and you can gather a lot of advantages there depending upon the nature of your business within the context of a properly constructed employment agreement. Number two, there is always the big issue of, if you have a truly important person to your business, a marketing person, a sales consultant, a researcher, a technology person who knows your secret sauce, and you have engaged that person as an independent contractor, it is much more difficult to retain the services of that person and to keep that person from helping out your competition if that person serves as an independent contractor as opposed to as an employee. In June, I'll be handling another program for MEA where we talk about how to retain key employees, different strategies beyond just non-compete provisions and the like, so-called golden handcuff provisions and other methodologies to retain your key employees and to keep them from assisting your competition. It's much easier to facilitate that if a key person is an employee as opposed to an independent contractor. So as these changes are coming down the pike and you're thinking about maybe getting a jump start, an advanced start on getting ahead of this curve, those are a couple things to think about, which might be advantageous to you if you control them properly. So I think that's all I can say now. Again, I stress to you, stay up to date. MEA will be your source of information on a continuing basis. But my sense is that very significant changes are now in the works. And over the next few months in particular, you're going to see some major indications of enforcement priorities and penalties and other strictures that will be imposed on all businesses in this area.
Thanks, Mike. We had a couple of questions, but I think they all kind of center on something that was striking me as you're talking. So we talk about the employer's responsibilities. What do you do with that? That person that wants to work for multiple companies, they don't want to be tied down, and they're kind of dividing up in, whether it's through a company like a, part-time, business offering part-time, or they just want to do freelance, whatever, whether it's IT or so on. How do you believe that these new rules are going to govern that situation when the person says, I don't really want to be your employee, I want to do other things? Can you get an affirmative waiver by the employee?
No, it probably won't work. What's important to understand is that even if someone works for multiple entities, they can still be an employee. Maybe they're a part-time employee, but they're still an employee. So one of the key factors is overtime. If you've classified someone as an independent contractor and they work more than 40 hours in a week, you don't owe them overtime. If they're an employee, you do. And even if they're a part-time employee, for example, they're only working a week or two at a time for you, If they are classified as nevertheless an employee, you're going to owe them overtime. And part of the changes that are being talked about is the nature of contributions to benefit plans, to health insurance and the like, that may be required in the gig worker community and in the part-time worker community, because the feeling is that a lot of these workers are falling through the cracks of the overtime protections and health insurance protections. And that's been one of the primary motivators of this, in addition to the government capturing withholding tax and FICA. So yes, you're going to have persons who want to be gig workers or persons who want to have the freedom to work for different companies. The thought process is that those people will still be classified as employees, be protected against overtime issues, and there will also be changes coming in the law with regard to how to handle the benefits.
So from an employer standpoint, then you're going to have to really think about what rights or benefits you offer to part-time employees versus full-time, because you may have to take a whole bunch of people and say, I can keep them under 25 hours and they're not going to receive benefits that another type of employee would.
And we don't know where those lines are going to be and exactly where they are. You know, in California, they classified the Uber drivers and the Lyft drivers as employees and imposed overtime requirements, even though they were, working a week or two at a time, hit and miss whenever they wanted. That got litigated, and Uber and Lyft won on the preliminary stages of that in terms of requiring that they be independent contractors. And the same thing's going to happen at the federal level. What will they be allowed to do? There's going to be litigation as to whether the administration has the flexibility to do it at once. So there's a big issue, and all I can tell you is that it is right in the center of the new Department of Labor head, Marty Welsh, the Biden administration center, and the person who's going to be hired as a part of the Department of Labor's effort to enforce the Fair Labor Standards Act. He has been campaigning to change the rules on part-time workers and gig workers for the last 10 years.
All right, and one final question. So if you are using a staffing firm and that person's an employee of another company, are you protected at that point, or do you still have an issue?
No, you're going to, one of the things that happened during the Biden administration already is the loosening up of the so-called joint employer standard. The Trump administration had tried to narrow that. Stated simply, the joint employer standard says that a person can be an employee of 2 different, 3 different, 4 different companies and still be an employee, not an independent contractor. The key aspect there is that if you have a staffing company that provides you with a person, and that person is working in the ordinary course of your business, that person is going to be your employee as well as the staffing company's employee, which means that that person's going to be entitled to overtime, ADA protection, harassment protection, discrimination protection. So one of the keys is what's your agreement with the staffing company say? Who has the responsibility for what in terms of managing that employee and handling the potential employment law problems that may arise? But that person's going to be an employee provided by a staffing company if they are doing work that's in the ordinary course of your business.
Great. All right. Mike, thanks again for joining us today. And like I said, these are topics that we'll stay on top of, and you can always reach out to the MEA's hotline and legal services for any questions you guys have, if you're members.
Very welcome. Thanks for the opportunity. Everybody stay well.
All right.
Thanks,
Amy's
Mike.
up.